Hi everybody, Sahm Manouchehri from Century Park Law Group. I got fabulous trial attorney Gary Dordick from Dordick Law Group here with us today, and we're discussing the most pressing topic in consumer rights. The initiative brought by big business, Big Corp, Big Oil, Big Farm, the Koch brothers, where they're trying to affect consumer rights by limiting the attorney's fees at 20%. Gary, as an attorney of many, many decades, how would a fee cap affect your ability to represent your clients and take on new cases?
Thank you. That's a great question. The problem obviously is they don't care about consumers. This initiative has nothing to do with getting injured people more money or more portion or a larger portion of their settlement. The idea is big insurance companies, big pharmacies, big business want to deny access to the courts. So what they're doing is they're falsely claiming it's for the benefit of the consumer, and the reality is it's going to prevent people from getting good lawyers. That's the bottom line, and that's what they're trying to do. Most lawyers, like most businesses, we run a profit margin of maybe 50% if we're lucky. If you properly staff and you properly work, you're lucky to even make 50% in this business we're in. If you cut our fees by 50%, many lawyers are not going to be able to stay in business. There'll be a lot of lawyers struggling to survive. Lawyers can't take smaller cases that are less profitable. Lawyers can't take riskier cases. Lawyers won't be able to finance the big cases against the pharmacies and the corporations that put profits before safety. So it's critical that to keep the courts open, to keep access, clients can always negotiate a fee. Clients can always, and they're free to negotiate a lower rate, and many lawyers do charge a lower rate, but across the board, it's completely unfair. It's going to destroy the legal profession, destroy access to the courts. I mean, do people really think that the insurance companies and big corporations are trying to help them? I mean, it's a joke. It's outrageous, but we have to get the message out. We have to raise the money, raise public awareness, and let them know that they're putting this initiative to cheat people, and so they can continue to put profits before safety, so they won't be held accountable for their misconduct, and we really need to do something about it now.
Thank you, Gary. As Gary succinctly explained, this is a farce. It is not pro-consumer rights. It's actually anti-consumer rights with a false labeling. Gary, thank you so much for your time. Always a pleasure. I have fabulous trial attorney Brian Panish of Panish, Shea, Boyle, and Ravipudi here. Brian, consumers are being presented this initiative that's been labeled a pro-consumer initiative by limiting the attorney's fees cap. Can you simply and succinctly explain to all consumers how limiting their ability to obtain an attorney is affected by the fact that you won't take as many cases on if you're being dictated the terms of the agreement with your clients?
Well, first of all, Sam, big companies have the right to contract and hire any attorney they want. A consumer has the right to hire any attorney they want if the attorney is available. With a reduction in fees, there will be less attorneys willing to take on cases that they take on now. They have to incur hundreds of thousands of dollars in costs to prosecute the case. They have to take a risk, and the only way that they're going to be incentivized to continue to represent these consumers with the risk they take is by being able to collect a full contingent fee. The contingent fee is the backbone of our civil justice system. Without contingent fee lawyers, victims and consumers will not have access to courts, and the courts will be closed and locked on them. Doing this of capping attorney fees will, in fact, deny justice and lock the courtrooms to many deserving consumers.
Brian Panish, everybody, at Panish, Shea, Boyle, and Ravipudi. Thank you so much, time. It's a pleasure to see you. Guys, we're at CAOC in San Francisco. Brian, what are you going to be speaking about at this seminar?
Actually, I'm just going to be introducing my good friend Benjamin L. Crump, civil justice advocate extraordinaire across America, and a good friend of mine, and he'll bring a lot to it today.
I got Neil McCarthy here of Cotchett, Petrie, and McCarthy, offices out of Santa Monica and San Francisco, specializing in mass tort and class action lawsuits. Neil, it's a pleasure to meet you. So what we're discussing is the fee cap initiative that big business is trying to get consumers to fall for as if it's pro-consumer, when in actuality it is anti-consumer. If such a bill were to pass, how would it affect your clients' ability to gain access to legal representation, assuming that your attorney's fees are capped at a certain percentage rather than negotiated through contract with your clients?
Well, it would be devastating. And in particular, it's going to affect the people who need representation the most. Your very large, high-end cases, those would likely go forward. The people who are going to be cheated are the marginal cases, the smaller cases that certainly can't afford hourly representation, and their only avenue to the courthouse is a contingency fee. And those cases will absolutely get wiped out, no question about that. And what's particularly insidious about these initiatives is they target California's consumer protection laws, 17200 and the CLRA, which are designed to protect people who get cheated in different types of scams. And by directly targeting those, what you're doing is giving a free pass to businesses.
So in essence, you're not only disincentivizing them from doing bad things, you're incentivizing them now because there's no stick to keep them in line, if you understand my saying.
That's exactly right. I mean, you have a situation where nobody now is going to be watching corporate behavior because they certainly don't self-police. And one of the benefits of the consumer class actions and consumer law is that you change corporate behavior. You just don't have individual recoveries. You make the business better for the future. And that benefit's going to be wiped out if these initiatives go forward. I mean, the saddest part of these initiatives, from my view, is that there's, of course, no limit on what corporations can spend on their lawyers. So only rich people and corporations are going to have lawyers. And the average Californian is going to be out in the cold.
Neil, thank you so much for your time. Neil McCarthy of Cotchett, Petrie, and McCarthy out of San Francisco and Santa Monica. Neil, it's a pleasure meeting you.
It's a pleasure to talk.
Deborah Chang from Chang Klein LLP here. And we're at the Advocates Club, where we're going to be discussing the topics that have been brought by different companies to try to create initiatives and ballots where they're trying to affect consumer rights. So Debbie, it's nice to meet you. It's a pleasure to meet you. I'm happy after all these years I finally got to meet you. And what the people are really asking about is, what are these initiatives and what is the purpose behind them? So first off, what is the initial initiative that's being brought by insurance companies and their lobbyists? And what is the purpose of them?
To summarize briefly, the overall purpose of these initiatives is to pretty much threaten the contingency fee and kind of dictate where the contingency fee should be. So what we have, and it's very clever how they're doing it. They're doing it through a entity called CJAC, and no one seems to know what CJAC is. It's very mysterious when you look them up, but when you unmask them, they tend to be big tobacco, alcohol, manufacturers, big oil, and tobacco. And the Koch brothers, and they're the corporate America who believe that it's okay for them to spend as many millions of dollars as they want to or wish to for their attorneys to enable them to do anything they want. And then they want to dictate how the little people, how much their attorney should be paid. That is so unfair, and that will lead to so much injustice.
The way I've read the initiatives is trying to imply that the attorneys recover all the money for themselves when, in fact, obviously the majority of any settlement or award does go to the client. How does capping an attorney's fees actually negatively affect the consumer? Even though the way the initiative is drafted, it's implying that they will get more money from this initiative becoming a bill. So what I'm asking, Debbie, is how does a cap on attorney's fees affect consumer rights?
Well, when you say all the money goes to the attorney, that's so not true. Most people out there who've had an injustice done, they've been catastrophically injured, they have been, their rights have been violated, they have been abused in some way by an entity, a defendant of some kind, whether it be a doctor, a corporation, a store, wherever. And then most average consumers cannot go to an attorney and say, I can pay you by the hour, like the defendants can. And so they have no money, they have no savings, and then the worst tragedy has happened to them. How are they going to even pay for the costs, the depositions, the discovery? So what they ask plaintiffs' attorneys to do is to fund their case for the entirety of that case. It could be 5 years where they don't pay a penny to the attorney. And the attorney is there taking a risk with them, saying, if you win, then I'll get paid. If you don't win, we don't get paid. And then it's that kind of system that allows the attorney to pay for all the costs, to pay for everything, to put the consumer on somewhat of an equal playing field in court and in litigation until the injustices can be exposed, which in turn makes the whole world safer for all consumers. So if you cut into the consumer's right to be on equal footing, what's going to happen is less and less attorneys will be able to afford to even take on certain cases, smaller cases, but cases that may be small to an attorney or to other people, but are everything to a family. People will not be willing to take those cases because it doesn't add up in the end. 5 years of work, doing it. And so all these, what people consider, smaller cases add up. Small injustices add up until the world is not safe, until the defendants basically can do anything they want because no one will catch them in the act. And I think it's just not good for anybody.
Absolutely. In essence, it's preventing consumers from obtaining legal representation because even though it's a small injustice in the big picture, to that one client, it's everything and they can't find a lawyer. So what is CAOC doing to ensure that consumers are not only educated about the fact that this is an anti-consumer initiative, what is CAOC doing to ensure that it doesn't actually become law?
Well, it's interesting. I think by doing this, they have actually done us a tremendous favor because it has mobilized us like nothing else. We've just come from a pandemic where our big concern was keeping the courts open, keeping just open, and, everyone's been kind of isolated. Well, we are now firmly together. We are firmly mobilized. And the CAOC, as always, we are planning our attack in many fronts because we can. And we are mobilizing everyone on a statewide basis. I think we've been able to raise money in 2 single days like nothing I've ever seen. And I think this is something that strikes at the very core of who we are as lawyers and who we are as the CAOC. We will stand up for the consumer no matter what. I mean, if you imagine a world without this arrangement, every car regulation that's in place right now, what makes people's cars work, not roll over, people don't fall out of their cars, is because a lawsuit was brought.